Good evening. My name is Bijoux.ngwanda, immigration lawyer here based in DC, family law lawyer based in DC. For immigration, I do work with individuals across the country and around the world because we're dealing with immigration cases, complex immigration cases. If you do need a consultation with me, please call my office 202-751-2180. Email is on display. Consultation fees apply as usual. We are going to be talking about the latest in immigration news, what's going on with immigration. Let's catch up with what's really going on. We have a lot of great news, but we'll focus on three major news. The first thing, good news for TPS holders in removal proceedings. So if we have TPS holder in removal proceedings, this is a great news because some people were in removal proceedings and couldn't adjust status because the DOJ uh, or DHS will not join the motion to dismiss and terminate the case so they can adjust status with USCIS. So the motion to reopen a case so that it can be terminated so they can adjust status with USCIS. They couldn't get that part done because remember, if you have an order of removal being order removed from the country, well, you can technically not adjust status with USCIS because you have to reopen the case first and get the case dismissed, closed, then go back to USCIS and adjust status. But certain individuals with TPS status were not able to do it. And there was a lawsuit going on for 2 years, and now we have the final result. USCIS has finally agreed and so to actually get those people to adjust status provided that they follow the procedures. So who is eligible? I'm going to share the screen with you so you know whether you're eligible or not, if it applies to you, so that you can pretty much ask for prosecutorial discretion, so that the government will close your case or dismiss the charges so you can adjust status with USCIS. Let's get with the sharing the screen. So we're going to read it. I'm going to try to explain briefly. But again, if you need a consultation and you feel like this is for you, you can always call my office or email me. Again, consultation fees apply as usual. So let's go with sharing the screen. Well, I'm going to share the screen here. Yeah, this is the settlement, right? It says stipulation of settlement and dismissal. So this was a lawsuit. The plaintiff were Central American Resources Center and others versus the director of USCIS and Citizenship and Immigration Services. That's the defendant, because people with TPS were trying to adjust status with USCIS, but they were being denied status because of the previous order of removal, right? So now what's going to happen moving forward? If you see, it says that the mentioned parties believe that the settlement of this action is in their best interest and best serves the interest of the public. These parties therefore stipulate that this stipulation constitutes the full and complete resolution of the issues raised by Kierson in the action and ask that the court order as follows, right? For a period from this date to January 19, 2025, okay, what's going to happen is the Office of Principal Legal Advisor of the U.S. Immigration and Customs Enforcement, ICE, will generally exercise its prosecutorial discretion by agreeing to join a motion to reopen and moving to dismiss the removal proceedings of an individual who meets the following criteria, right? Must be currently possess a temporary protected status, has a removal, deportation, or exclusion order issued by the Executive Office of Immigration Review or its predecessor agency, the U.S. Immigration and Naturalization Service, has traveled on advance parole since that order was issued and is otherwise prima facie eligible to file an application for adjustment of status with USCIS, including but not limited to those with a pending or approved I-130 immediate relative visa petition who meet the inspected and admitted or parole requirement of the Immigration and Nationality Act as amended pursuant to USCIS policy if seeking to adjust under that provision, right? If USCIS granted or renewed temporary protected status, so, and then it goes on and on. So briefly, what's going on is this, right? Certain people who currently possess TPS couldn't adjust status because they had a previous order of removal with the immigration court. And ICE was not agreeing to actually reopen the case and dismiss it so that they can adjust status with USCIS. Because remember, if someone has been ordered removed, or if someone is in removal, really what it is you cannot adjust status with USCIS. It's either you adjust status in court when the case is open, or if the case has already been closed and they already removed, order you remove, you have to reopen the case and pretty much ask for dismissal so that the case can be closed, which we call it prosecutorial discretion, so the charge will be dismissed. Then you go back to USCIS to adjust status, and certain individual couldn't do it because DHS will not allow them to, will not join the motion to reopen a case because it has been a long time. Really, you have to, in order for you to reopen a case, you have to have a joint motion. So like government agrees, and then you go with it to the judge, and the judge reopen the case and officially dismiss those charges and dismiss the removal. Then you have the right to go back to USCIS and adjust status. But certain individual with TPS couldn't do it. So now, because of this stipulation, this agreement, then they will be able to do it. But remember, if you have TPS and you had a previous order of removal, but still you enter without inspection, even though you acquire parole later on based on your TPS, advanced parole, you're still not going to be qualified because you have still to meet the requirement of adjustment of status in terms of being admissible. So enter must have been inspected or parole at the time of entry, and provided that you don't have any other criminal issues. So this is very crucial. So if you don't understand it, you need to call me so that we can discuss it, okay? And pay your consultation fees. But again, those are the four criteria for those that actually qualify, right? Then we go to the next news. USCIS urges eligible individual to consider applying for adjustment of status in the EB2 category based on the April visa bulletin date for filing for India. So this is really good because remember last time we were talking about the fact that USCIS is encouraging a lot of people to change eligibility category when it comes to employment-based type of visa because they have a lot of visa available. And we go back again, now they're doing the same thing again, really trying to encourage individuals. So if you have an application for EB2, now is really the time to go for it because they have a lot of availability when it comes to EB2. Remember, EB2, national interest waiver type of green card-based employment. So really, this is good news, okay? So it says here, if you are a non-citizen who has an approved immigrant visa in the EB2 category chargeable to India and the priority date earlier than 1/2014, USCIS encourage you to consider applying for adjustment of status in April by filing the form I-485, and you should include I-693 with the form to save time. You're not required to do it at the first time you file form I-485, but filing both form at the same time may eliminate the need for USCIS to issue a request for evidence in order to obtain the form I-693. So basically what they're saying, well, if you fall into that category, you can apply for adjustment of status, and just make sure that you apply with the I-693, the report of medical examination and vaccination of record at the same time, so that you can, in order to avoid delay of your application, right? So usually we just apply and then wait for them to issue a request for evidence, then we send them the I-693, but they're really encouraging you to apply with everything together. But it's not a requirement, but it is an encouragement. So then, as previously said, they're still continuing to encourage eligible applicants to consider requesting to transfer the underlying basis of the pending adjustment of status application in the EB3 category to EB1 or EB2, right? If they meet the following criteria, a visa is unavailable to them in EB3, they have pending or approved I-140, and the visa is available in the EB1 or EB2 category. So basically, if you are into the EB3 category, they're trying to tell you really to transfer to EB1, EB2 if you have a form I-140 pending or approved, because you can adjust status quickly, because there's a number of visas available in the EB2 category. So basically, really, you just have to go ahead and transfer that and try to get into EB2 category so you can get your green card as soon as possible. This is a great news because they really have a lot of employment EB2 type of visa available for a lot of qualifying candidates. So basically, that's what it is. You can read it for yourself. Well, again, really, this is a good news. Okay, I'm gonna stop sharing here, and I am going to come back here. And lastly, the last news that we have is that DHS is on its own really is dismissing other cases, right? If you happen to have a pending I-485 application with the court, right? DHS, and then your court date individual hearing is in 2023, DHS is actually really just closing your case or dismissing the case so that you can just apply with USCIS. You're not going to lose your time in the line. What's going to happen? They're just going to go with the time you apply with the court and follow along with USCIS, and that's what they're doing, which is a good thing, because adjusting status in court can be really challenging because they have a different how they say it, they have different standard for the judges adjusting your status. There's a lot of different standard than when you just go straight with USCIS. So if DHS is doing it, the Department of Homeland Security is doing it, this is a great news. And if you think that you qualify, but you haven't seen your case being dismissed so that you can adjust with USCIS, well, you can ask for prosecutorial discretion based on just that alone, because first of all, in order for you to ask for that in that category, you have to know, consider the requirement, right? You have an individual hearing in 2023, and you have an I-485 adjustment of status application pending with the court. That's how it's gonna play out. That's when you can ask DHS to just close the case so you can just go straight with USCIS without losing your place in line. Pretty much that's what it is. This is it for today, okay? Tonight. So if you need a consultation, again, 202-751-2180. Consultation fees apply. I have to reiterate on it. Email is on display. Please comment, share, like, and again, please follow me on Twitter, Instagram, Facebook page. This is my pretty much my social media account. That's where you can follow me and get the most updated information. Okay, so until next time.